speaking with me, Tarun Nangia. Justice NV Ramana, a first-generation lawyer, will take over as the Chief Justice of India on April 24th, which is this very month. Now, a very forward-looking judge. Even before he's become Chief Justice, he's made some big announcements. He's spoken about creating a national infrastructure corporation for the judiciary to take judicial infrastructure into the future. We all know that there are a lot of issues regarding judicial infrastructure in India, even at the High Court level, even at the Supreme Court level now, because the special times of Corona that we are in, we required much advanced infrastructure. Well, what are his challenges and what are his opportunities in his tenure? To discuss this, I have a very eminent panel with me. I have with me Senior Advocate Mukul Rohatgi. He served as the Attorney General of India, the first port of call for corporates all over the country whenever they want to argue a matter in the Supreme Court. He's counted as one of the leading lawyers of India. For well over 2 decades now, he's been in the top run. I have with me Dr. Abhishek Manu Singhvi, eminent jurist, one of the foremost lawyers of India. He also is a third-time sitting Rajya Sabha member of Parliament and someone who anybody, all big names that you can count when they're in trouble or if there is a corporate fight, you see Dr. Abhishek Manu Singhvi's appearance in court. And it's quite interesting that many times Dr. Singhvi and Mukul are appearing on one, he appears for one party and Mukul Rohatgi would appear for the other. I have with me Ryan Karanjawala. He heads one of India's leading litigation law firms, namely Karanjawala and Company. They were in huge, big news recently, having won the matter for Ratan Tata, as in the Tata Trust. Many congratulations to you for that, securing that order.
Well, you'll also have to congratulate both Mukul and Manu, because they've all been on my side. So,
and to both of you too. But getting back to the topic on our Chief Justice of India designate, Justice NV Ramana. Mr. Karanjawala, could you open the whole discussion by sharing with us the opportunities as well as the challenges that Justice Ramana will face?
Well, Tarun, the first thing to remember is that a Chief Justice, and especially a Chief Justice of India, is not just a judge with additional duties. It's far more. In fact, most people feel, and people who have studied the subject say, that the Chief Justice of India is the most powerful judge in the world. And the reason for that is threefold or fourfold. First, he is the Chief Justice of a country with one of the world's largest populations, 1.1 billion people. Two, the second reason is the nature of the Supreme Court itself. The Supreme Court is not a constitutional court. It is any matter filed in any part of the country can ultimately find its way up to the Supreme Court. So it's a court of every kind of matter and any kind of matter. Three, the power of the Supreme Court of India. It can not only strike down legislation, it can strike down constitutional amendments. And fourth, the intrinsic power that a Chief Justice has, which is different from that of any other judge. He has the right to make benches and he has the right to allocate matters. This, people feel, has made him the most powerful judge in the world. Now, when you look at such a position, the question that you have to ask yourself, and people do often ask, is what are the qualities that this judge must have? What are the attributes that he must have to make a distinctive or an exceptional Chief Justice? And in my mind, there are 3 or 4 qualities. And on scrutiny, I find that Chief Justice Ramana fits the bill on every count. First, the judge should have a sense of purpose, a clarity of thought as to where he wants the court to go, where he wants to take it. And if you look at Ramana's utterances, if you look at his judgments, you can find out the following things. 1, he's pro-women. 2, he's pro-liberty. 3, he's pro-poor. And 4, he is for the poor at the lower ranks of the ladder getting easy access to the courts. So I feel that he's a judge with a vision, and I think that's a very important prerequisite. Second, the judge must have energy. In fact, when he becomes the Chief Justice of India, he must have more energy than when he was first elevated to the court. And if you see the utterances of Justice Ramana, you will find that he's almost raring to go and grapple with the problems at hand. Third, the third is he must have administrative experience. He must not be a novice in the matters of administration of justice. And Justice Ramana has fortunately been the Chief Justice of two different high courts, the Andhra Pradesh High Court and the Delhi High Court. The stints were short in both places, but nevertheless, he has an administrative experience of both South and North. And the fourth and most important thing for him, is that the judge must have time. Justice Ramana has 16 months. So he has a lot of time to have an impact. And I do feel and I do hope that this time will be utilized to have the impact that it should have on the court. Because unfortunately, Chief Justice Bobde's tenure was spent grappling with the problems of COVID. He couldn't really take the court much more forward than he has. Justice Ramana has a great opportunity, and I look forward to him becoming the Chief Justice.
Okay. Mr. Rohgi, your comment on the opportunities and challenges for Justice NV Ramana.
See, I have seen Justice Ramana now for more than 10 years in the Supreme Court and the Delhi High Court. I find that he is a practical and a common sense oriented judge. The fact that, he came from a small village, came to Hyderabad, started working as a lawyer, being a first generation lawyer, this will help him immensely in understanding the problems and woes of the poor, the uneducated, the people not having wherewithal, not being able to go to different lawyers and different courts. That will certainly help him in driving the court to a situation where justice becomes accessible to all. And I have heard him say at many stages, and I think that's a very, very important feature. It's all right for us lawyers that we are in the Supreme Court, we are practicing, people come to us and we appear. But imagine how it starts. It starts in the Mufassil court. There's a lawyer there, there may be a judge in the Mufassil court, some decision is taken, something in appeal, something in the Supreme, in the High Court, then the Supreme Court. Access is most important. And till COVID, the access was not that simple because you have to physically file a petition in the Supreme Court. It involves 1,000 pages. They have to be tagged together. They have to be, put together, etc., etc. COVID has shown some ways of e-filing and stuff like that, but the court has to go a long way. So there's no doubt it will help him. The second most important thing for a Chief Justice, apart from the abilities and about the traits which Mr. Karanjwala just said, the most important thing is that he has to be a captain of the team. He has to take the team together. Now, one clear thought comes to my mind. Though Justice Bobde has always been a sensible, middle-of-the-road person, he's not an extreme kind of a person. He doesn't have extreme thoughts. But for some reason, in the last 15 months in the Supreme Court, single appointment has taken place in the Supreme Court. I am not blaming Bobde or X or Y. The fact of the matter is that the collegium has not been able to see eye to eye. The result is there are 4 or 5 vacancies in the court. Now, if this kind of thing happens, the court, the judiciary, the entire infrastructure from top to bottom is creaking under a huge load of arrears. Now, the arrears will go on mounting. If 5 out of 31 Supreme Court places, 5 are vacant, or 300 or 200 are vacant in the high courts, they're going to be a chaos. So not only has he to take his team forward, he has to also have a cordial and a sensible relationship with the government, at least the appointments. I mean, we expect him to be independent, not that he will lead in favor of the government in a case, but he has to have cordial relations with the establishment. Otherwise, if the same thing happens which happened in the last 16 months, we are heading for a disaster. So I expect, knowing Justice Ramana, he has no airs, he's a sensible chap, with a level-headed person, so he should be able to carry it forward. That, according to me, is his most important, one of the most important priorities. The third is, see, you may talk, and I've seen every Chief Justice talk about areas for the last 25 years, but nothing has happened. Areas haven't come down. Because, you take one step forward, it becomes 2 steps back because of the burden. The burden is not because only of the court or the infrastructure. The burden, a lot of things add to that burden. Lawyers asking for adjournments, lengthy arguments, lot of docket, a lot of cases being filed, less judges, archaic laws, multiple appeals. So there are many things. So if the Chief Justice has to holistically look at reducing the areas, they cannot be reduced just by appointing judges. There has to be a multi-pronged approach of all these problems. And if, as Ryan said, Justice Ramana has a decent tenure, the tenure is much less than the tenures abroad, but it's still a decent tenure. He has to then grapple with these multi-pronged problems to see and then have a good dialogue with the government and other stakeholders, maybe lawyers, body of lawyers, bar associations, how to bring down the areas. So if you have to act on these 3-4 fronts. But I think he fits the bill. He should be able to maybe achieve some part of what I have discussed. And even if that happens, I think it's a good start. And maybe the other Chief Justice to follow can also go on the same path.
A couple of very good points from Mr. Rohgi. Dr. Singhvi, in your opinion, the opinions, in a sense, the challenges and the opportunities that you see Justice Ramana has.
Well, much of what I wanted to say has been said. But let me start and divide my responses into the personal and the institutional, both of which matter. Now, at the personal level, as we all know, and we are, all daily practitioners, we are spending our life in this system. I think he clearly is a pragmatic, hands-on, result-oriented person. That makes a lot of difference. Today, that great juristic erudition, which is also very good, may not actually work in the multifaceted tasks which the Chief Justice has to handle, which is a lot of pragmatic, hands-on, result-oriented panaceas, which he has to formulate. And I think in that, Justice Ramana, anybody who knows him, sees that he is that approach, finding a solution. Secondly, at the personal level, I think merely being a Chief Justice of Delhi High Court is a great bonus. I'm not putting Delhi High Court, after all high courts are equal in that sense, but some are more equal than others, as George Orwell said. So Delhi High Court is clearly more equal than others because it's a great experience for anybody to pass through Delhi High Court. It is an experience in 3 things: person management, solid, substantive diversity of substantive law, and also logistics management. So I think Delhi High Court training or experience is something which will stand him in good stead. And we found some of those talents displayed in the relatively short tenure he had in Delhi High Court. And all of us have appeared before him. Third is, at a personal level, I think his demeanor, his mannerisms, the ambience in his court is pleasant. We tend to underestimate that. I don't want to name people, but we've had terrible situations on this very obvious thing in some courts at some times. We all know who practice. We know those names or some of those names. It doesn't help. I can be very egotistic. I can give a lecture, a sermon, a didactic thing from the pulpit because I know that Mr. Karanjawala is only a lawyer. He's hearing me, he has to hear me, he has to suffer me out. It doesn't help. It doesn't help the institution. It doesn't get things going. It doesn't solve the problem. It creates more acrimony and tension. This is something obvious, but yet it has not always worked. Justice Ramana scores high on that demeanor component. Fourth is, I think the way he has conducted himself with dignified silence in the context of some recent controversies. Now, those are not necessarily, he has not activated or done anything about it. It's just started. But it's tried to engulf him and he has maintained a dignified silence, which I think goes to his enormous credit. And fifthly, on his entry point and his personal thing, I think he's also fortunate in that he has an excellent, if I may use the word wrongly, but I mean I'm using it in a different sense, set of deputies in the collegium. You know, he has a very good crop of people. Unfortunately, we are losing Justice Nariman shortly. But there are lots of other people who are constructive, positive, and with the requisite give and take, I think they are reform oriented. So he's inheriting not a bad collegium. Sometimes these are legacy issues, not of your making. I may inherit ABC, which doesn't work for me. So I think this is as far as the personal is concerned. On the institutional, I wanted to say 2 or 3 things. One is that this areas thing, as Mukul rightly said, you know, this has been, and I've been writing about this for the last 15 years, the last being in the quarterly bar review of the High Court. One major part, certainly appointment of judges is not the only panacea, but certainly equally in a country of this size with a litigating public of maybe 300 million or 250 million, to have at any point of time in our 70-year history, 1/3 High Court posts vacant. At any point in 72 years or 74 years. So you cannot deal with arrears, and for that, you need to cut out this nonsense of second referrals again being delayed. There's a very small little foolish thing happening. I recommend Mr. Karanjewala, his name goes up. It comes back for some reason. I recommend him the second time in the collegium. The judgments make it clear there is no discretion after that. None. 9 judges, 7 judges. But you'll be astonished at the number of cases which still pend by neither saying yes nor no to the second reference of Mr. Karanjewala by me, the collegium. Now, I had written, and I'm quite frank about it, suppose in one case, the Supreme Court was to issue a notice of contempt to the law secretary. I'm not suggesting ex-law secretary, Y law minister. I'm not concerned about political dispensation. But this has to end. There is no discretion for delay after that. So these are the kind of concrete steps. And now I am seeing the beginnings. I don't want to mention the bench. Benches of the Supreme Court, a particular bench of the Supreme Court tasked with this is looking into this. That how can vacancies continue after second decisions? Then again, 2 things I find which Chief Justices have not done. I think Justice Ramana as a challenge and as an initiative and as a novelty should do. One is, I think it's time that we stopped using this as a kind of a cloistered virtue where I have all the power, I am the Chief Justice. You know, Ryan is right in more than one way, because Indian judicial review of the Supreme Court even 30 years ago, and now I would say 30 times more, would make Marbury and Madison in the US Supreme Court blush. Our judicial review, nothing in size, scope, degree, no other country has anything compared to it. So that power sometimes makes the Chief Justice centralize, over-centralize. I think amongst the challenges he must do is he must delegate. He must create a baton system. This collegium has passing on the baton and somehow manage to create that continuity. That happens also, I think, by a lack of transparency even within the collegium, in the sense that there's no harm in preparing a 5-point agenda. Now, the agenda need not be published officially, but a 5-point agenda that I intend to start and accomplish these 5 things. Take, for example, judicial infrastructure, which you mentioned. There is already in the press, there are materials showing that you want to make e-filing and e-courts everywhere in the country. Now, that could be one item on the agenda. Take your 3 and 5 collegium into confidence and push that. Because in India, what hurts is that you have mid-course changes. You have mid-course corrections for no reason. Decide a policy with 3 or 5 of your colleagues and then push it without change for 5 years. You'll see the difference in 3 years. Push it for 3 years. And you have enough Chief Justices in your collegium to do that for 3 years. I think that consensus should be built on agenda, not merely on judicial appointments. That consensus on agendas is not done because somehow people tend to function in isolated silos. And that must change. So I think if he does these 3-4 things, a person with the temperamental equipment will go very far in doing institutional change also.
Mr. Karanjewala, you heard Mr. Rohgi speak and Dr. Singhvi speak on judicial appointments, on consensus building, on relations with the government with regards to appointments, which Mr. Rohgi pointed out, on the few points that Dr. Singhvi made. Do you want to add to anything of those?
No, I just want to take further what both of them said. And I think it was points which were very well made. What Manu and Mukul both emphasized was that for the Chief Justice to succeed, it's not just that he should be a good captain. He must take along his team. There must be teamwork. And Manu's point was absolutely valid. Have an agenda set informally, among friends, in the collegium. Decide like a common minimum program that, all right, between us, this tenure of this collegium will last, say, 4 or 5 years. What are the things we need to achieve? The obvious one, of course, is to see that the court is manned at full strength. Now, that's not a very difficult thing to do if you're able to get down to do it. Also, if you have informal consultations with the government, emphasize that, look, this is something that we are absolutely determined to have. We are not going to allow you to, through delays, allow the court to function in a truncated manner. This is something that the judges can all get together behind. And once a united front is put forward by the collegium, sooner or later, you'll find things happening, both in the Supreme Court and in the High Court. And, at no point, in fact, should, according to me, there be a vacancy of more than 5 or 3, maybe at the most 10% in any forum. You should ensure that that just gets done. And maybe the time has come for them to decide as to whether sending it back for the second time does not necessitate almost an automatic affirmation by the government, and it automatically just goes for the warrant being issued for the judge being made. So these are things that the Chief Justice should build on. And the important thing, which everyone seems to agree, is that his temperament is such that it can allow him to make best use of the talent that he has before him. He has 2 outstanding judges of exceptional caliber and many more. But the 2 outstanding judges are Rohinton and Dhananjay, very learned, make use of that talent, sit together, come out with an agenda and go forward with it. I fully agree with what both Mukul and Manu said. This is the way to go forward, and this should be the way to go forward.
Mr. Rodgi, you represent very high stake matters, but the pendency is 66,000. In a COVID year, do you think that the times are going to be tougher for Justice NV Ramana? Because even as he takes over, till about December at least, COVID doesn't seem to be going away.
You are right, Tarun. He will inherit maybe the last part of COVID, hopefully. But the point is that he has to try and make it easier, that is, access to justice easier. And let me tell you a small thing. Till about 10 days ago, no mentioning was allowed in the Supreme Court for the last 1 year, which is a complete anathema to the functioning of any court. So suppose I have a very urgent case of somebody's bail, somebody's arrest, some other problem. I should have a right to mention it to the Chief Justice or to the judge in charge that matter should be listed as early as possible. But that was not allowed. And people were asked only to go to the registrar. Sometimes the registrar doesn't understand it, but it's just been allowed. Now, Justice Ramana has to iron out these problems, iron out these creases, problems, whatever you call them. That, this is a part of access to justice. What I'm telling you, a small thing, but it has very, very great repercussions. If you can't get a hearing, there have been some, people have been raising doubts. Why did X journalist get a hearing the next day? Why did not somebody else get a hearing? These have to be ironed out because they ultimately reflect upon the ability and integrity of a court. That is justice meant only for somebody who can engage Mr. X, Mr. Y, or tell the registry that this case should be listed tomorrow and no other case would be listed. So he has to look at this also. The image of the court is also very, very important. The court draws its power not merely from the Constitution. Let us be very clear. The court draws its power or the belief in people of a judiciary from what the people feel about the court. The foundations of the court is not merely in the Constitution. It is in the belief of its people. And therefore, the ability, integrity, the way the court functions and works is very, very important from public perception. He has to look at that also. There have been a lot of doubts and murmurs in the last few months, about some journalists, as I told you, getting a chance of appearing, of having a matter listed. Some cartoonists cases are being taken up in contempt that they have painted the Supreme Court in a wrong light, stuff like that. So he has to look at that. But let me tell you, on a slightly larger issue, and that is this, and I sincerely feel about it. As both my friends have said, there is no doubt that the judicial review sweep of the Supreme Court of India is the greatest in the world. No doubt. Every decision, every order, every policy, every judgment, every tribunal is subject to the Supreme Court. You may take pride in that fact. But is it the correct path? Was this the path which the constitution makers envisioned when they framed it? Or they framed it as an apex court, like little wider jurisdiction than the Supreme Court? Or did they frame it the way the Supreme Court is functioning today? So some amount of introspection has to be done to see what is the future roadmap of the judiciary or the Supreme Court. For example, the Supreme Court was never meant to sit in small benches of 2 judges. So today we have reached a situation that if you have 30 judges, you make 15 benches of 2 judges each, and 1 bench of 3, because 31 is an odd figure. The Supreme Court was never meant to do that. So today Supreme Court is deciding every case like an appellate court over the High Court. It was never meant to be a mere appellate court to correct every error or to wipe every tear from every eye. It was not meant to be that. It was meant to be a constitutional court, essentially. Right? Now, if you are only going to pursue that line, that if you have 31 judges, tomorrow you have 35, you can have 17 benches. The problem is you are then deciding every matter like a mundane court of appeal. And if you don't agree with the High Court, you reverse it. If there's a court above the Supreme Court, it would reverse the Supreme Court. Now, is that the path which was meant to go forward? Because if you go on this path, the areas will never come down. More and more appeals will be filed, more and more things will be decided. Same thing will happen in the High Court. This will become a glorified High Court. That's not what the Supreme Court was meant to be. Now, let me tell you, some matters which are referred to 9 judges are pending since 2002. 20 years have gone by. The court, the Chief Justice doesn't have 9 judges to spare. So what is going to happen? We have at least 200 cases of 5 judges or 7 judges bench strength required. When will they work? When will they sit? Therefore, the Chief Justice has to have this vision, take his judges with him, maybe have a, what do you call it? Let's call it a legal audit of the past or a restatement, what it was meant to be, what is it doing? There have been studies that the Supreme Court has quashed economic decisions which has cost the nation lakhs of crores. I mean, I don't want to give examples. Lakhs of crores. Was that the vision of the Supreme Court envisioned in the Constitution? So I think that is something which is very, very important, apart from merely adding the judges or having them appointed and stuff like that. What is the roadmap? Where are we heading? So if you are just going to blunder or, just kind of stagger along, I mean, last 30, 40 years that we have been seeing in our practice, whether Singhvi or me or Ryan, 40 years we have been in it or more. Well, ultimately, what has happened? The number of cases are rising. People are saying that it takes 2 generations for a civil matter to be decided. I mean, one has to look at that reality. A lot of people who are not in the judicial in this profession, whether a judge or a lawyer or who have been litigants, they have a very different approach. They're very critical that what kind of system is going on, stuff like that. So I wish that Justice Ramana, being a practical person, will also look at this. What is the roadmap of the court? That's what
point taken, a set of very good points made by Mr. Rodgi, but we are completely out of time on part 1 of the episode on Justice NV Ramana taking over as Chief Justice, opportunities and challenges. On the other side, in part 2, we'll have Dr. Singhvi share his opinion on what Mr. Rodgi just started. But thank you so much, Mr. Rodgi, Dr. Singhvi, and Mr. Karanjawala for sparing time for part 1 of this episode. We'll see you on the other side. Thank you viewers for watching. Thank you so much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.